Discussions on artificial intelligence, particularly generative AI, are everywhere. It is changing workplaces and education faster than anyone can truly keep up with. The large language models behind generative AI are trained on millions of texts, images, songs, videos, and other media. Each of these individual pieces of training data represent a great deal of knowledge, talent, and hard work by human creators and are examples of something called intellectual property. There are legal protections that define how people can and cannot use other people's intellectual property. However, how those laws that were created for human users apply to GenAI is still up for debate. What is copyright? Before diving into intellectual property issues in GenAI, let's explore some background information. Copyright is one of the most common intellectual property protections and was originally conceived to encourage innovation and creativity through granting creators certain rights to determine how their work can be consumed and reproduced, often protecting their ability to make money from their creative works. While in the United States many creators and publishers file for copyright protections with the U.S. Copyright Office, any work created with human creativity is automatically granted copyright protections as soon as it's created. Copyrighted works are protected from activities such as copying the works exactly or even very closely, public performances, and illegal streaming without the copyright holder's permission. For example, when authors want to use a photograph, they need to obtain permission from whoever owns the photograph, unless it exists in the public domain. Illegal copying of copyrighted works is often called piracy. Fines for copyright violation historically have been quite significant. In 2001, a number of major record companies sued the peer-to-peer song-sharing platform Napster, with fines so high they led to the company's demise. In 2011, Stanford student and hacker Aaron Swartz was charged with 13 counts of fraud for downloading millions of articles from the JSTOR database, possibly to share with people who didn't have subscription access to them. He was threatened with 35 years in prison and a $1 million fine, but died before his case went to court. The internet provides access to enormous amounts of information, and each information resource may have been made available legally with the rights holder's permission, or illegally. It is critically important to understand that just because something is made available on the internet does not mean it can be used however one wants. Copyright protections still apply. Copyright laws provide some key exceptions to owners' rights to control their intellectual property. One of the most important exceptions is something called fair use. The fair use exception allows creators to use pieces of someone else's copyrighted work to comment on, criticize, parody, teach, or research. When copyright laws were made, the concept of fair use was intentionally vague and has been hotly debated on a case-by-case basis in courts ever since. Traits that help make a successful fair use case include the purpose of the use, with not-for-profit, educational, and transformative use, is more likely to be considered fair use. The nature of the copyrighted work, with more protections being granted for more creative and artistic works. The amount of the original work used, with smaller pieces of works more likely to be permissible. How the use affects the market price of the original work. GenAI companies' arguments for the extensive use of other people's work without consent, notification, or compensation centers around this hotly debated concept of what constitutes transformative fair use. Protection of GenAI's inputs. GenAI requires massive amounts of training data in their models, significantly more information than Aaron Swartz downloaded from JSTOR. To give just one example, Stability AI's Leon 5B model has scraped over 5.8 billion images from the internet. The internet provides a convenient portal for AI tool developers to access this vast amount of information. The scraping of information to pull into training data storage is automated and occurs at such a massive scale that asking individual creators of training data items for consent is impossible. However, much of the information sources being added to training data has historically been protected from being copied or used in unauthorized ways, even when made available on the internet. How existing intellectual property laws should apply to large language models and GenAI tools is hotly debated. Currently, AI companies have been largely successful in arguing that their gathering of copyrighted training data falls under fair use and is necessary to further technological innovation and win the AI wars. However, many writers, artists, musicians, and publishers are upset that their intellectual property has been sucked into the training data for large language models. They argue that these tools' outputs frequently resemble the individual works in their training data, undermining claims that the use of training data is transformative. While AI companies have been very secretive about the contents of their training data, visual artists using their own names in text-to-image tool prompts find these tools' instantly produced images eerily similar to their own art. AI-generated music is beginning to appear on popular streaming platforms such as Spotify, raising questions for listeners about the ethics of this music's similarity to the work of human musicians. Additionally, traffic to websites is dwindling as people turn to AI tools for information rather than the original information sources, which causes a loss of revenue for many sites. Because AI tool owners make money on subscription users' use of these tools, while in turn the original creators of the training data are often losing money, many creators argue this cannot be fair use as it harms the market value of the original works. Many people see the court's current permissions to collect the intellectual property of others as inconsistent with past legal actions, such as those with Napster and Aaron Swartz. However, legal issues that currently favor GenAI companies are far from settled in courts. The Australian government appears to be siding with creators who seek to protect their work from being added to GenAI training models. Authors have recently won a major victory in an unprecedented $1.5 billion settlement with Anthropic, the company behind Claude, which used 7 million pirated books in their training data. It's important to note in this case that the primary issue was that Anthropic obtained these books from a website that did not have permission to post them, and the judge explicitly stated that the training use was exceedingly transformative and therefore fair use if the books had been legally obtained. In another ongoing case, leaked internal documents may show that OpenAI willfully violated copyright laws when it downloaded the same pirated library even if it later deleted the data. This evidence could significantly increase the monetary damages rights holders could demand when this case goes to court or when OpenAI settles. Protection of GenAI's outputs. While there are ongoing arguments between the rights holders of the intellectual property that goes into training data, currently the legal intellectual property protections of AI-generated works are more straightforward. The U.S. Copyright Office has determined that media made solely through prompting with generative AI tools cannot be copyrighted. Works created primarily by humans with AI assistance are still copyrightable, but how much AI use is allowed in the creation process in order to still receive copyright protections is not clear. We can expect to see many more lawsuits challenging the decision to prohibit copyright of AI-generated works, as well as case-by-case lawsuits about how much AI assistance is too much. Conclusion. There is a significant tension between creators who have created the massive amount of intellectual property that makes up GenAI's training data, and the GenAI companies who have scraped their works from the internet. With simple prompts, GenAI tools can create outputs that are very similar to the individual creator's work, and GenAI poses a significant threat to the livelihoods of the creators who have unwillingly supplied the human intellectual property on which GenAI tools were built. So far, the U.S. courts are siding with AI companies, calling their vast scraping of others' intellectual property fair use, although they are not giving intellectual property protections for generated works. All we know for sure right now is that this debate over intellectual property issues will continue as long as GenAI continues to grow.